The Supreme Court just delivered a massive smackdown to the ATF in the lawsuit Garland versus Cargill, which was the lawsuit challenging the ATF's 2018 Bumpstcok ban. In that ruling, the Supreme Court said that Congress had not banned bump stocks, that the definition of machine gun did not include bump stocks, and that the ATF was acting outside its authority to ban them. This is going to have a massive domino effect on the ATF's other unconstitutional gun control actions and rules, including their ban on forced reset triggers. That case is currently pending at the district court level, where we hope to have a ruling soon on our summary judgment motion. So a lot of good news coming, hopefully in the days ahead, and I am going to let Lawrence DeMonico tell you right now a little bit more about this lawsuit.
Hey guys, it's Lawrence DeMonico here, president of Rare Breed Triggers. It's been a minute since I put out a video, but I'm coming at you today with some breaking news from the United States Supreme Court. The Bumpstcok ban has been officially struck down. That's right, the ATF's unconstitutional Bumpstcok ban has been finally struck down. This is amazing news, and based on the language used in the ruling, it has a direct impact on our efforts to end the ATF's illegal attack on forced reset triggers. Today, I'm going to talk to you about what the Garland v. Cargill decision means for all of our forced reset cases. But first, I want to stress this. If you are not a member of the National Association for Gun Rights, you need to fix that and become a member right now, especially if you're a fan of Rare Breed Triggers or our forced reset trigger products. Go to notriggerban.com and sign up today. We'll put the link in the bio, the description, somewhere. Find the link, make it happen. The fact of the matter is right now, Judge O'Connor out of the federal court in the Northern District of Texas has an injunction against the DOJ and ATF's illegal ban on forced reset triggers. But with that said, it only applies to the plaintiffs and their members. And the plaintiffs include the National Association for Gun Rights. That's why we encourage you to sign up and become a member of NAGR. Now, I feel like I've got to put this out there. The level of protection provided to new members has not been litigated, so please do not sign up for that reason alone. Rather, sign up to help me, help Rare Breed Triggers, help all freedom-loving Americans put an end to the ATF's ban on FRTs. NAGR is the only national group fighting to do this, and if you sign up for membership today, your membership will go to help Rare Breed Triggers in our legal defense case in New York and NAGR's legal efforts to overturn the FRT ban in the Northern District of Texas. Okay, so here's the meat and potatoes. Here's what today's Cargill decision means for all of us. First, let me say right out of the gate that it is an amazing ruling. The list of things that I'd like to cover is quite long, but I'd like to keep this video on the shorter side, so I'm only going to share a few specific items with you. Okay. So in their ruling, the Supreme Court held that for most firearms, including the ones at issue here, the trigger is a curved metal lever. On weapons with these standard trigger mechanisms, the phrase function of the trigger means the physical trigger movement required to shoot the firearm. All right? And next, the Supreme Court stated that a bump stock does not convert a semi-automatic rifle into a machine gun any more than a shooter with a lightning fast trigger finger does. Even with a bump stock, a semi-automatic rifle will fire only one shot for every function of the trigger. Okay, next, the Supreme Court stated that Congress has long restricted access to machine guns, a category of firearms defined by the ability to shoot automatically more than one shot by a single function of the trigger. And then goes on to state that semi-automatic firearms, which require shooters to re-engage the trigger for every shot, are not machine guns. All right, next, the Supreme Court stated that 5845B does not define a machine gun based on what type of human input engages the trigger, whether it be a pull, a bump, or something else. Nor does it define a machine gun based on whether the shooter has assistance engaging the trigger. The statutory definition instead hinges on how many shots discharge when the shooter engages the trigger. And as we have explained, a semi-automatic rifle will fire only one shot each time the shooter engages the trigger, with or without a bump stock. And last, the Supreme Court stated that, as all agree, a semi-automatic rifle cannot fire more than one shot automatically by a single function of the trigger, because the shooter must do more than simply engage the trigger one time. The same is true of a semi-automatic rifle equipped with a bump stock. Now, Call me crazy, but the way I see it, you could simply swap the words bump stock with force reset trigger in each of these previous statements, and they still ring true. Ladies and gentlemen, this is a bombshell ruling against the bump stock ban, but also against the force reset trigger ban that I and rare breed triggers have become infamous for. This is one of the key legal arguments we have been making from day one. FRTs are not machine guns, and they do not convert any firearm into a machine gun. It's so refreshing to see the Supreme Court explain what's been so blatantly obvious to gun owners for years. And I'm convinced more than ever that if an FRT case actually makes its way before the Supreme Court, that they will strike down that ban just like Justice Thomas did in the Bumpstcok case today. But hear me now when I say Cargill is not our case, and I'm not going to hold my breath and expect the ATF to obey it as it relates to FRTs. To date, Cargill has done nothing to change the ATF's opinion and policy on FRTs. And Cargill has done nothing to stop the DOJ in New York from trying to ruin rare breed triggers and my livelihood and the livelihood of our staff, vendors, and customers. While this is an amazing ruling, we now have to take this ruling and carry it through both Rare Breed's defensive case in New York and the National Association for Gun Rights case in Texas. Your right to own a forced reset trigger will not be assured until there's victory in both. So with that said, we cannot take our foot off the gas. We have to fight harder now than we ever have before. Litigating in district court, the appellate courts, all the way to the Supreme Court is not cheap. In fact, it's incredibly expensive. So please hear me loud and clear when I say this. Rare Breed Triggers is the only manufacturer, and the National Association for Gun Rights is the only national organization to draw a line in the sand and stand up to the ATF for forced reset triggers. So it's absolutely critical that while we're fighting a legal fight in both the defensive case out of New York and the Second Circuit, where courts generally are very hostile to the Second Amendment, that we support the National Association for Gun Rights in their efforts to help end the ATF's illegal ban on forced reset triggers, stop Congress from mucking it up, and to support Rare Breed Triggers in our fight against the weaponized DOJ in New York so that we can again resume making legal products for all law-abiding gun owners. Guys, I've said it once and I'll say it again. I gave everyone my word that I would see this through to the end, and now I feel like we're getting there. This is the beginning of the end. Let's just take this ruling and take it all the way. Thanks for your support.